Judge Piet Koen has dismissed former President Jacob Zuma's bid to have State Prosecutor Billy Downer recuse himself from his arms deal corruption trial. The judge upheld his previous ruling on the matter, citing that there is no merit in granting the application as it will delay the main trial unnecessarily. The former president is facing corruption charges relating to a multi-million rand arms deal. Zuma accuses Downer of being biased.
I accordingly conclude that an appeal, and hence an application for leave to appeal in respect thereof, should not be entertained at this stage of the trial against the two accused. If that had been the only issue in the application for leave to appeal, I might have been disposed to granting leave to appeal on the basis that the law might be uncertain on this issue. However, even assuming and proceeding on the basis that it is accepted for the purposes of this judgment, that the dismissal of the special plea is appealable at this stage, I am satisfied that the application for leave to appeal should nevertheless be dismissed on the basis that it lacks reasonable prospects of success.
Well, joining us now for more on the story is Advocate Romeo Ntabeleni. Advocate Ntabeleni, when one listens to Judge Piet Koen talking about the trial then commencing on the 11th of April, he sounds very sure that that will be the case. But I think for everybody else who might be looking from the outside at this case and just how many different legal challenges and surprises that have been in the pipeworks, can and will this case go ahead on the 11th?
Yeah, it's a very good question that you are actually asking, and I'm afraid also I don't have an answer. But as you are actually correctly saying, that looking from the outside, it looks like there's going to be a petition to the SCA, and then but a petition, in principle, whether it will stop the proceedings is another question. And then because now the judges ruled that the matter should proceed, and then on the 11th. So on the 11th, we believe that based on the judgment that the court has given today, that the appeal should proceed. But if they have petition, obviously they will have to wait for the Supreme Court of Appeal to actually entertain the petition before we even go to the trial. But more or less, the judge is saying, let's just get on with it and proceed with this trial without any further delays.
If you were a lawyer, particularly who believes that their client has been unfairly treated and will be subjected to an unfair trial, are there loopholes that you think you would be looking at right now to ensure that this trial does not go ahead, at least not with the individual that you believe is prejudicial against your client?
Yeah, I think it depends also on the facts, Kathy. And here what we are looking at and the nature in which the proceedings has been conducted, the judge lamented it in this judgment to say, these were unnecessary hurdles and unnecessary delays that are actually thrown on the way that the trial should actually not proceed. And the Constitution discourages approaching criminal trials on piecemeal basis. And then he cited the judgment of S versus Roslin that actually support that contention to say that when you are dealing with issues in a criminal trial that are appealable, you first wait for the conviction. The court must first make a decision in finding the accused person guilty or not guilty. Then you can appeal on the basis that you wanted to actually appeal. And that is the basis of a solid ground that the judge in his 61 pages judgment has actually set out today, Kate, and he said, don't put the cart before the horse. Wait for the proceedings to unfold, and then you will have the opportunity to be able to bring, any appeals on any basis and any grounds, whatsoever.
The former president's defenders will look at that judgment and say, well, this is yet another reason why he is a victim of the justice system in the country, that he has to undergo this trial again with somebody that he believes does not even have the title to be prosecuting him. So just so that we're clear on the facts of this case, Advocate Ntabeleni, is what Judge Koen ruled today, is that what due process, the legal due process, has that been followed?
Yeah, no, it's a solid judgment, Kathy, and let's not forget, the law is not what you wish it to be. It is what it is. And that is basically what the judge actually ruled. In terms of following the Constitution, following the rule of law, following the case law, the judgment that was granted today, ticks all the boxes in terms of, following the law. But as you have rightfully said, Kathy, that when you are looking on it for the other side, you actually ask your question whether, there can be still some room to actually maneuver on behalf of your client, and that's why we spoke about, the petition to the SCA, and then we have seen it with other cases where the SCA has looked at the petition and dismissed it outright, due to lack of prospects of actually success. So this is a similar case in this instance.
Should the Supreme Court of Appeal, throw out that appeal, as you're saying, that petition, as you're saying, is this a matter that we're likely to see go before the Constitutional Court?
Yeah, the possibilities are high. Looking at the litigant that we are actually dealing with here, and you're looking at the raising of Section 35 rights in terms of the Constitution, and then I think that, the chances are very, very, very much high that we might actually end at the Constitutional Court, raising the constitutional issues, also basing on the argument, that was actually, put forward in relation to the interest of justice and also the accused's rights. But Judge Koen interpreted the accused's rights very much correctly and says the accused's rights don't actually have to be used to abuse the court process and proceedings. And perhaps the law surely should be tried on that to actually make sure that the right proceedings are being followed without either side actually abusing the rules of the court to their benefit, because the gaps are open in terms of the Constitution, in terms of how you interpret it, depending on which side you are actually sitting on. Okay.
Legal analyst Romeo Ntabeleni, let me thank you for your time tonight.